morning, Madam Chair and members of the Judiciary Committee. I'm Shannon McGinley, appearing representing Cornerstone in support of HB 396. I want to talk about the Federal Department of Education's recent final rule, which is 30 CFR Part 106, and how it might relate to this bill. Although I'm not an attorney, the facts can be readily verified with any knowledgeable attorney. First, there's some misunderstanding about what the final DOE rule actually claims to do. Some media reports have described the rule as prohibiting all differentiation based on biological sex. Actually, in several places, the Biden DOE is now saying Title IX allows people to be separated based on biological sex as opposed to gender identity in, quote, sex-separate living facilities and sex-separate athletic teams, unquote. You can see this in the DOE's own final rule summary on its own website or in the final rule under section 106.31, subsection 2, which actually uses language pretty similar to HB 396 as passed by the House. This should be important to the Senate for at least a couple of reasons. First, you can see that the position taken by the Biden DOE in this new rule is significantly more conservative than the views of the New Hampshire Department of Justice over the past 2 years. The DOJ has repeatedly shown up at committees and falsely claimed that federal law somehow prohibits sex separation in student athletics. The fact that even the Biden DOE now disagrees with that vindicates what Cornerstone has been saying over the past years, that the DOJ has been taking a progressive activist position, not giving a straightforward description of the law. Secondly, when you look at how much overlap there is between HB 396 and the DOE rule, you can see that it would make no sense to try to weaken the House bill as a compromise. HB 396, as introduced, which simply clarified that using biological sex is allowed, was already so moderate that it would have sounded like a joke and a piece of satire even just 10 years ago. But this House version you have now is already an even more watered down version of that bill. The text in front of you is the most watered down thing that could possibly be effective at affording any protection to women and girls. Weaker language would actively worsen the situation of girls in Milford, Interlakes, and other districts who are being bullied and treated unfairly and whose privacy is being violated right now. Finally, let me mention the most objectionable part of the Biden DOE rule. On page 1,270, yes, there's 1,500 pages to the rule, of the final rule, it says that while teams and athletic facilities can be sex differentiated, girls in restrooms and locker rooms must be forcibly exposed to the genitals of males. While we obviously strongly oppose that policy rule, the policy in the rule, it does not create any legal problem for this bill or even a legal challenge. This is a bill that says that New Hampshire state law does not prohibit sex separation in these circumstances. If the Biden administration was right to say that federal law does prohibit sex separation, there would be no contradiction or grounds for any legal challenge whatsoever on this bill. You can see that if you just simply use logic, there would be a contradiction and challenge only if the state law mandated what federal rules prohibit. 2 more points. If schools do choose to go against the DOE rule and set up a legal challenge, this bill is not requiring them to do that. That could happen tomorrow with or without this bill. Lastly, of course, Cornerstone hopes that the new DOE rule will be eventually struck down, but in the meantime, passing this bill will not create any conceivable grounds for any kind of federal legal action against New Hampshire.